Hi, this is trial attorney Diane Cafferata, and today I'm going to talk to you about how to protect your trade secrets. Under California and federal trade secrets law, you have to have reasonable measures employed to protect your trade secrets. If your company has not employed these reasonable measures to protect them, then the law concludes that you don't really value them that much. Beyond that, the law really doesn't express exactly what they mean by reasonable measures because in different situations, reasonable measures mean different things. When I think of reasonable measures, I generally put them in three broad categories. The first of these broad categories are legal measures, and they're pretty straightforward. Most companies have them in place, but if you don't have them all in place, then you should think about what others to put in place to make sure that basically all of the employees know that they are supposed to be protecting your proprietary information. And they include non-disclosure agreements, confidentiality agreements, company policies that talk about how to handle sensitive materials, and then entry and exit paperwork for your employees so that everybody knows their obligations. And then to go along with that, you want to make sure that your company is actually abiding by those policies and procedures that it has put in place, making sure that the employees are signing on to that documentation, that they're receiving the right information when they're advised of their obligations to the company, make sure that everybody gets an employee handbook, all that sort of thing. The second category are physical measures, and these are what you might assume they are, like badges that identify an employee when they're walking through the facility, make sure that only the right people have those badges, passcodes or keys to unlock doors so that only the right employees have access to certain types of information. Okay, and then the third category includes electronic measures that are taken to protect confidential information. So that might be the use of passwords on computers or certain types of, firewalls, ways that companies can limit the access of certain types of information to just the employees that have a need to know that information. It could also involve, two-step authentication and other, anti-phishing measures, training for employees to make sure that they recognize threats to the company's confidentiality. And these reasonable measures aren't just important to make sure that the court knows that you think they have value. In fact, reasonable efforts to keep your trade secrets secret is an element of what makes them a trade secret. And that's true under CUTSA, the California Trade Secrets Act, and under the DTSA, which is the federal equivalent.